This is Sean Keith with Keith Law Group. I want to talk about joint and several liability in the state of Arkansas. And I'm going to talk about it in context of injury and specifically in regards to a car wreck. Let's say you're in a car wreck and it's not your fault. It's the fault of the other driver. And in this case, it's a fault of two or three other drivers. Who can you recover against? Let's say, and let me give you a case study, someone runs you off the road. You get run off the road as a result of somebody's negligence. And then a second car comes up and you're off the road and isn't paying attention and slams into you. Happens more times than you would think. People, if you ever get pushed off the road or you have to pull over on the shoulder on a busy highway or interstate, get way over. Get almost on the grass or on the grass. People drift over that fog line all the time. So let's say you get hit and then you have to pull over and then another person comes up and they hit you as well. Okay? Joint several liability in Arkansas would say that both people are at fault. And where this becomes important is, let's say that the first person only has $25,000 in insurance coverage, and the second person has $100,000. And your damages are worth a lot more. They're worth $150,000. Okay? And we'll talk about damages in another video. But let's say that your injuries, your medical bills, your wage loss is $150,000. Okay? And you settle with the first person for $25,000. You get that money. Their insurance company says, here it is. The second person says, well, we're not at fault because we wouldn't have hit you but for the first person. Okay? Well, our argument would be, absolutely, you're at fault. You're still negligent for not paying attention and hitting us. So if this case goes to trial under the joint and several rules in Arkansas, the jury has to assess damages. And let's say they come up and they say, your damages are $100,000. All right? Then they get to know how much the first person who settled with you paid. So they get to know that you've already received $25,000. And therefore, if they want, and really, if they want to assess the full 100 against the second person, plus the 25, they would need to say that your damages are 125. If they want to assess 75,000, they can do that as well. But the jury gets to know in one instance, or at the option of the defendant, the jury doesn't know, and the judge just reduces whatever judgment you get. So in this case scenario, if the second defendant says, I don't want the jury to know, and the jury comes back and says there's $100,000 in damages, then the judge will deduct the first $25,000, and then will assess the second person $75,000 that they have to pay. It's a little bit complicated. I hope I've explained it well. If you have any questions about this or anything else in regards to car wreck cases, motor vehicle accidents, injuries, don't hesitate to call us at Keith Law Group. If you've been in a wreck, whether you call me, you call someone else, you need to get an attorney. The insurance company is working very hard. They have a lot of people who work for them in order to make sure that you're paid the very least for your injuries. That's their job. Your job is to get better. My job is to fight the insurance company for you.